Hello everyone, my name is Carla Casas. I'm an immigration attorney in Chicago. My firm is Casas Immigration. And today I want to talk to individuals who have DACA, the Deferred Action for Childhood Arrivals program. I have a very special place in my heart for my DACA clients because I was also brought to this country as a child by my parents. I was lucky that we came in 1980. Right in time for amnesty, and so I was able to obtain my green card in the 1980s and eventually became a citizen. But I could definitely relate to having been brought to this country. It wasn't my choice to come here. This is the country I've grown up in, the only country I've ever known, and I know that's how a lot of my DACA clients feel, so I can definitely relate to that on a very personal level. And today I want to talk to you about green card options for individuals who currently have DACA. As most of you know, the Supreme Court we're awaiting a decision from the Supreme Court regarding whether the Trump administration can terminate the DACA program. A lot of my clients who currently have DACA are understandably very nervous and anxious about this decision because it could impact their future in a very significant way if the Supreme Court decides to allow the Trump administration to terminate DACA. So in light of that, I want to discuss with you some potential green card avenues for individuals who currently have DACA. So the first thing I want to make sure you understand that you can pursue both avenues at the same time, meaning that if you are eligible to renew your DACA, you should absolutely renew it, assuming there's no risks involved with your case. And at the same time, you can also start on the green card path if you have an option for a green card. You don't have to choose one or the other. You can do both at the same time. And in fact, I encourage most of my clients to continue renewing their DACA as long as they're eligible while we pursue the green card, because as you will see, as we'll discuss in this video, it's quite a process. It could take a couple of years or longer, depending on which avenue you're on. And so it's a good idea to continue renewing that DACA if you're eligible to do so. So I'm going to focus this video on family green card options. There may also be other potential avenues, for example, through employment for some DACA recipients. But my practice, we focus on family immigration cases, and that's what the focus of this video will be. And these are the ones that we most commonly see. But again, there may be other potential avenues in your case. So with regard to family green card cases, I want to talk about having an immediate relative petition for you. An immediate relative would be your spouse if they're a U.S. citizen, your parent if they're a U.S. citizen, if you're under 21 years old, or your children if they're over 21 and older and they're U.S. citizens. If you have those family members if they are U.S. citizens, then they can file a petition for you, and it's considered an immediate relative petition, so there is no wait list, there's no wait time. You basically submit it, and USCIS will start processing it as soon as you submit it. So there's two avenues that you can take in terms of getting the green card. So the first one is called adjustment of status, and that is when you file a green card application here in the country with USCIS. Your interview is here. You don't ever have to leave the country, and you're basically adjusting from one status to another. So if you're currently DACA, you'd be adjusting to green card status. Now, the catch is not everybody is eligible for adjustment of status, so you have to have a legal entry to be able to apply for adjustment of status. So that could be, you entered with a tourist visa or a student visa, or if for certain DACA recipients who were able to get a travel document approved and were able to travel when the administration was still approving those, if you traveled and entered with that document, then you may also be eligible for adjustment of status. There are a couple of exceptions for individuals who do not have a legal entry but may still be eligible for adjustment of status. The first one is if you had a petition filed on your behalf prior to April 30th, 2001, or if you had a petition filed maybe on your parents' behalf, if you were a child at the time. I have a client whose uncle filed a petition on behalf of his father, back in the 90s while he was still a child, so he was included in that petition. So if you have that situation, then you may also be eligible for adjustment of status. These are 245I cases. That refers to this section of the law, but the most important thing to know is if you have a petition that was filed on your behalf prior to April 30th, 2001, then you may have an avenue for adjustment. And then the last one is parole in place, and this applies if you have a family member who is in the armed forces. Either they were in the armed forces and were on early discharge, or are currently active in the armed forces. And this would be a spouse, parent, son, or daughter. So if one of those family members is in the armed forces, you may be eligible for parole in place, which would then allow you to file for adjustment of status. So first you would have to seek the parole in place, which is a separate application on its own. I will mention that the Trump administration has been wanting to terminate this program, but so far it is still in place. It has not been terminated. I recently got a parole in place approved just a few months ago. So I encourage you to explore that option quickly if you think you might be eligible for that. In terms of the timing for adjustment of status, I would say between 6 months and a year. Obviously, some cases are approved faster, some take longer, but I would say that's the average based on what I've seen in my office. Between 6 months and a year is what you can expect. If you're not eligible for adjustment of status, then you will have to do what's called consular processing. So this is where your family member will file an immigrant petition for you, the I-130 petition. Once that gets approved, then you would need to schedule your interview at the U.S. Embassy or consulate in your country of birth. But before you leave, you have to, if you've accrued any unlawful presence in this country, so any period of time that you've been living without authorization to be here, if you've accrued more than 180 days of unlawful presence, then you're going to need a waiver, because if you leave the country without that waiver, you're going to be stuck outside for between 3 years and 10 years, depending on how much unlawful presence you've accrued. So I will mention again with DACA recipients, if unlawful presence starts accruing at age 18. So if you obtained DACA prior to turning 18 years old, then you may not need a waiver for unlawful presence, because during the time that you've had DACA, assuming that you've always renewed your DACA, you've never had any lapses, you may not have accrued any unlawful presence. So that's something you'll definitely want to confirm with your immigration attorney, but there's a possibility that you may not need a waiver. And the advantage of that is your process will be shorter, because the waiver does obviously take more time, to be able to finish the process. So for the majority of people who will need waivers, the waiver has to be based on your U.S. citizen or legal permanent resident spouse or parent. It can't be based on your child. So if you have U.S. citizen children but no spouse or parents, then you will not be eligible for the waiver. For the waiver, you'll have to convince the government that the relative who it's based on is going to suffer an extreme hardship if you are not granted the waiver, and if you have to be outside the country for many years. So that could be a video in itself in terms of how to prove extreme hardship. But just keep that in mind, that you may need to submit a waiver if you've accrued more than 180 days of unlawful presence. Once you have that waiver approved, then you can go ahead and move forward to the final piece, which is scheduling the immigrant visa interview at the consulate, and you'll have to, again, do an electronic visa application. You'll have to submit additional documents, but that will be the final stage of the process. All in all, I would say, between 1.5 to 2.5, maybe 3 years in some cases for this process, for consular processing. So it is a bit longer than adjustment of status. But it will depend, how long the I-130 petition takes. I just had a record approval in 28 days. We had an approval within 28 days of filing the petition, but that is definitely not the norm. I would say normally it takes about average of 6 months to get that petition approved. It could be longer, so just give yourself plenty of time for that. Again, I just want to mention that these are not the only options, but these are the ones we most commonly see in my practice. And so I think it's a good idea, again, for you to explore these options. The idea is you want to minimize the amount of time that you could be without authorization. If the Supreme Court allows the Trump administration to end DACA, you could have a lapse where you don't have anything. You don't have any work permit. You don't have a green card. So the idea is to go ahead and get started on the process, get that ball rolling if you are eligible for a green card. Again, I think I want to make clear that you should not do this on your own. Immigration law can be very complicated. There may be other factors that apply to your case. You'll need to make sure you're eligible for these benefits before you apply. It's very risky nowadays to apply for something if you could be deportable based on, your background, based on the facts in your case. So it's important to, talk with your immigration attorney. If you had someone who helped you with your DACA, an immigration attorney who helped you with DACA, feel free to reach out to them, get some more information, or you can also reach out to us. I consult with clients all over the country. We do telephonic, video consultations, and I'd be happy to talk with you to explore those options so that you have a plan in place. Our number here is 312-971-7221. You can also email me, carla@casasimmigration.com. Or you can also find us on Facebook at Casas Immigration. Thank you so much for listening. I am, trying to stay positive about the Supreme Court decision, but at the same time, I think it's important to have a plan in place so that you know what your options are, and ideally, you can get started on your green card process if you have an avenue that is available to you. Have a wonderful night.